going to talk about the battle for religious freedom in the disciplinary tribunals right up to the High Court in Australia. In the darkest hour of Western democracy in 1940, Sir Winston Churchill made his immortal speech, "We shall fight them on the beaches, we shall fight them in the streets, we shall never surrender." And we're going to talk today about street warfare in the smallest tribunals right up to the High Court, because a number of us have taken it upon ourselves, or it's been put on our heart by God, that we have to fight. And with ACL and John Steinoff, Robert Balzola, who speak after me, and we will never surrender. We will fight. So the first case I want to talk about is about a young man in a public university in Australia who effectively, because he prayed for a student and because he spoke in response to a question as to what his views about a person who practiced homosexuality, was suspended halfway through his final year. This was the story. He was at uni, and a girl said to him she was feeling stressed. He said, "Could I pray for you?" She said yes, so he prayed, and she reported him to the university. A little while later, he came to his class, and a group of his mates said to him, what would you do if you were homosexual? He said, "I'd be kind and loving, but I wouldn't agree." They reported him. And a formal meeting was convened with the dean, or with the head of school. And the formal notification was that he had declared views about homosexuality in class and had given unwanted attention to female students. Example, praying for a student without consent, and that consent, by the way, was hotly contested. On my client's view, he had been given consent. He asked the girl if he could pray, and she said yes. So the dean, at this initial meeting, the head of school found there had been a breach of the code of conduct, and he was told he could continue with his course, but he mustn't speak to this girl apart from classroom activities. He was organising the end-of-year exhibition for his particular course, and in class he asked her twice if she would participate. She didn't answer, and she reported him, and he was summarily and unilaterally suspended halfway through his final year. And the breach of the code of conduct was he breached the safe teaching, learning and social environment which embraces diversity. Diversity for everybody, but someone who held views like him. So after he was suspended, a tribunal was convened. Now you might think that's a bit back to front, but they first executed him, then they tried him. The tribunal was convened, and his suspension was confirmed, and he was told he was not to come back on campus for the rest of that year. If he did, security would escort him off. That he was to have 3 counselling sessions that year, and when he came back the next year, ad infinitum for the course of the year, he would have to have 2 weekly counselling classes. So that was his fate. So we challenged the university's actions, first on the basis that the code of conduct, the complaints resolutions procedure hadn't been followed. There were a number of steps. They had to have an informal meeting with the complainant, and then, most importantly, the head of school, if they suspected misconduct, had to report the matter to the Vice-Chancellor. And it's only if the Vice-Chancellor thought there wasn't misconduct that it could come back to the head of school. But the head of school unilaterally suspended the lad. Secondly, the statutes of the university prescribed a procedure that had to be followed in setting up a tribunal. the tribunal had to have 7 people. A chairman appointed by the VC, 3 academics, and 3 students. The tribunal and the chairman couldn't be a person who was the head of the academic unit. The tribunal that was set up was chaired by the Pro-Vice Chancellor, who was the head of the academic unit. They had 5 others, 3 academic staff, and 2 administrative staff. And the statute also expressly prohibited administrative staff being part of the tribunal. So we said to the university, you've got it wrong, you better withdraw this suspension. And this was halfway through the year. So we appealed, and we had a mediation, and the young lad was allowed to come back the next year with no note of any disciplinary proceedings on his record and no counselling. So what's the lesson for that? The lesson for that, and this is one of the reasons HRLA has been set up, is that expert legal assistance is required right at the base level. We have to get it right from there, because it's too late once you get to the appeals and the Supreme Court, etc. If the base hasn't been set properly, you have difficulties upstream. So the first thing is you need expert assistance right at the base level. And that's why ACL has set up HRLA, and you can give John a ring. I'm sure he'd love to take a call. I'm always happy to help, because we have to get it right from the start. The second issue is that it's critical to insist on the mandated procedures. You can win these cases on the merits, but it's far better to win it on procedure. A win is a win is a win. And the third issue is that attack is the best form of defense. So what we did to the university is we wrote them a strong letter that said, you've got it wrong. If you don't change this, we're going to go to the Supreme Court. So what's the effect on religious freedom? The rubric of safe and inclusive teaching diversity is used to suppress Christian truth, because the gospel challenges a person at the deepest moral level. You have here 2 worldviews. You have the worldview espoused by this safe, diverse teaching, which says, do not challenge my thinking. You have the teaching of the Lord Jesus, who said, look, you are wrong. Out of the heart of man come evil thoughts. And those 2 things are in irreconcilable conflict. So it was critical that we held the line. And in this young man's own words, it gave him courage to continue speaking. From the universities to the schools. Now, some of these cases, I can't give you the jurisdictions and some of the details because they're subject to confidentiality and client confidentiality. But this was a case of a Christian college, we call them ex-college, and E, the student, alleged that he, that was the pronoun the student used, had been discriminated against because they hadn't been allowed to wear trousers, the boys' uniform, when they were in fact suffering from gender dysphoria and identified as a girl. Now, they'd been in the school in 2012. This claim was for 6 months. This claim was brought 3 years later, after they left the school. The relief sought, in addition to a declaration and compensation, was that the school, which was established on an express Christian ethos, would adopt the department policies in relation to gender issues. In the particular state that it was in, that meant adoption of the whole safe schools policy. So it was an attack on the very structure, the very foundation of the school. The other relief that was sought was that the teachers and students be subject to diversity training, and the proposition was that there would be training not by psychologists or educationalists, but by gender activists from groups like Gen Y, -18, etc. So again, this was an attempt to intrude directly into the operation and the minds of teachers and students. So we resisted the claim on the basis, first, there wasn't discrimination because the student had enrolled as a girl, self-identified as a girl, and apart from the one or two incidents where there was a testing of the uniform, had no trouble in the school. So we argued there was no discrimination. In fact, there was no more unfavorable treatment. Yes. Although given the legislation in that particular state, there were some difficulties with that. More importantly, the exemptions, or as I prefer to call them, balancing clauses, had said that a school could be run according to the doctrines of the religion. And this particular school had well-developed policies on the issue of humanity, or what is a man, what is a woman. And so what I say now to schools or any educational Christian body is you have to have developed doctrines, not just on God and salvation, but on marriage, sexuality, and gender. You have to have that. And if you want a template, go to the Billy Graham Evangelistic Association. Yes. In their statement of faith, they've got an excellent couple of paragraphs on those issues. So we were quite prepared to argue the doctrinal defense. We had a mediation and we settled. Now the lessons were that when they came to us, this school was under pressure by its legal advisors to adopt a settlement which would have meant that they adopted policies like the Safe Schools policy and allowed some training. And we said we don't have to do anything. The lesson is that schools need expert but sympathetic advice to help them retain their ethos and to fight to do that. If the original settlement had gone through, or the order had been made at some later point in a trial, the very ethos of the school would have been changed. And that was the stated aim of the litigation. It was what was pleaded in the court documents. So that school was able to operate freely. Then we come to Jason Tay, the photographer case from here. So Jason was a Christian photographer who was asked to take some photographs of an acquaintance from school. He found out she was in a same-sex relationship. And he said this to her. He said, look, I tell people who ask me about same-sex weddings that I'll do them, but I have a conflict. He said, I'm a Christian and have a conflict with respect to photographing their weddings. I'm not sure if the same applies, and I'm happy to shoot their family photos. And mark these words, we'll do it with skill and professionalism, but think I should let you know of my views. So this, someone said he refused to take the photos. That was not the case. He expressly said he would do them with skill and professionalism. But he made a declaration like in a conflict situation. Now, because of that, proceedings were commenced in the complaint was made to the EO Commissioner, and she took it on. And we argued that there was no treatment unfavorable under the EO Act here, because under the EO Act here, discrimination itself is not prohibited unless there are three consequences with respect to goods and services. Either there's a refusal to provide the service, or secondly, the service is provided on unfavorable terms and conditions, or thirdly, the manner in which the services were provided were different. Now, all they could argue was the manner. And our submission, and I think it's right, is this, that given the principle of legality, which means that you construe a statute according to the preserving as far as possible the common law rights and freedoms. It is not possible for the law to say what you should think inside. Given that he had said he would fulfill the contract if it was anything to do with skill and professionalism, that was all that he could ever be required, and the law could never go beyond that. So there was a conciliation conference, and at the conference the conciliation officer said that they thought this was a clear case of discrimination, and that if it went on to the SAT, the tribunal, the EO commissioner would provide legal advice and assistance for the complainant. And Jason then had a choice. He was told he could apologize, a public apology on Facebook, everything would be right. But he said, I couldn't be true to my Lord and do that. So we refused the settlement and took it on to the tribunal, and the complainant discontinued her claim when she knew she had a fight on. Now, the lesson for that is that sometimes courage is required and not compromise. Now, that is not to say you don't compromise on some occasions. As lawyers, we're not here to push issues when it's a court case. We're here to get the best practical settlement for the client. But on some issues, you need to stand your ground and fight. Because the lesson for religious freedom is this. The complaint was based on a mere expression of a view. That is it. That is all. And had that succeeded, it would be the law in this state that in most commercial relationships, an expression of a view could be unlawful discrimination if it's contrary to the accepted view. Now, that didn't happen here because a strong stand was taken. But it's still open. And Warner Spiker from Spiker Legal ran the case here. I was counsel from Adelaide. And we did that pro bono. Most of these cases are run pro bono. So if you're short of funds, we might help you. If you're nice. Now, from business to the streets. You may have heard of the street preachers case from Adelaide, where a group of street preachers challenged the bylaws in Adelaide, which prohibited them from preaching on the streets without a license. They won at district court. They won it on appeal in the Supreme Court when they were self-represented. They got representation in the High Court because the High Court required them to be represented. And guess what? They lost. But Caleb left Adelaide and went to Launceston and applied for a permit to preach in the malls in Launceston. Now, the bylaw in Launceston said that you can't preach without a permit. But the council had, a bit like the planning issue, the council had some guidelines which said that preaching or political spruiking was not a permitted use. So the application was refused. So we sued in the federal court, and we argued that the decision was beyond power because the guidelines were inconsistent with the bylaw and therefore had to be invalid, and that the council officer had therefore taken into account irrelevant considerations. We also argued the implied freedom of political communication. Justice Tracy in the federal court held that, firstly, that the council officer was not an authorised officer under the relevant bylaw, so the decision was void. He held that the guidelines did not apply to the particular application, and they were inconsistent with the bylaw and therefore were invalid. So we won, and most importantly for the lawyers, we got costs. Now, that's not being facetious because that sounded very strongly across the councils in Tasmania, and I'll explain why that was important in a moment. So the lessons for that is that when the next case came up in Tasmania, which is a case of Mazur against G, I'll explain that in a moment, the Hobart City Council dealt with a street evangelist very gently because they knew there were people behind him who were ready to fight. Mazur, I'm sorry, I'll skip ahead. The lesson here is that councils, since the first street preachers case, have been telling people, particularly Christian people who apply for a permit, that our bylaws are valid and that our decisions are valid. But this corner loop decision impacted on councils on that particular way they were trying to run things. The impact on religious freedom was that Caleb was able to preach pretty freely in Launceston Mall for months to come. Council had a bit of a go at him. We helped him through that. And so that was important. And then when he came to the next case, as I said, the Hobart City Council dealt fairly warily with a street evangelist. Mazur was a serial antagonist to the man David G, who was a street preacher evangelist for the Cornerstone Presbyterian Church. So mark this is a Presbyterian church, a Reformed, not any way out Christian sect. And so he was preaching in the speaker's corner in Hobart Mall. And Mazur, according to papers filed by G in the magistrate's court, would come and shout and create a nuisance and generally create threats. So G sought an intervention order, and as part of those proceedings, Mazur gave an undertaking to the court not to harass him. Mazur then reported him to the Anti-Discrimination, the Equal Opportunity Commissioner, for a number of things. In a fairly diffuse sort of application, he alleged that there were things said about Islam, about homosexuality, etc. And the commissioner distilled that diffuse complaint into 17 specific allegations. And one of those was this. This was the allegation of offensive conduct under Section 17 of the Tasmanian Equal Opportunity Act, which is the offensive speech section. That the best kids is in a strong marriage. Think of things like this. The state shouldn't redefine something which naturally produces the best interests of the child. Now this was when marriage was at law between a man and a woman. It was the law of the land, and the commissioner took this on as being an offence, as being contrary to Section 17 of the Tasmanian Equal Opportunity Act, the Offensive Speech Act, because somebody had this sign on a table in the mall in Hobart. That was one of the matters raised. So we then sued the Equal Opportunity Commission in the Supreme Court. We challenged Section 17 itself on the basis of the implied freedom, and we sought judicial review of the decision to take the complaint on, because under the EO Act in Tasmania, a person who brings a complaint has to be a person who shares in those protected attributes or is affected by the particular so-called offensive behaviour. And Mazur wasn't a homosexual, he wasn't is a Muslim, etc. We don't know why, but Mazur then abandoned the complaint. And so the judicial review aspect had fallen away. We were left with a constitutional issue, and because of issues of costs, the client decided not to go on. Unfortunately, in another case in Tasmania, a case of Durston, a self-represented person argued the implied freedom in the Supreme Court and lost. The court found that though the Section 17 on its own arguably infringes the implied freedom, because there's a defence of of something done in a public act, the freedom wasn't improperly burdened. But the court said very tellingly, and this wasn't argued, it should have been, that Section 17 applies not just to public speech, but mark this, private speech. So, lastly, the impact on religious freedom then is that Christianity is, Mazur said that Christianity is something which comforts, but first to comfort has to cause discomfort, which is the gospel. And it was an effort to stop the preaching of the gospel, not just in the streets, but anywhere publicly. Lastly, we come to Club and Preston. I ran the trials in Club and Preston in Tasmania and Victoria, and I was counsel in the High Court. We lost 7-zip, and that was pretty sad. But I want to highlight a couple of things. The plurality, 3 judges, Chief Justice Kiefel, Bell, and Keane, said that, generally speaking, to force a person to hear a political message is inconsistent with the human dignity of that person. And they founded their judgment on this concept of human dignity, quoting from Aaron Barak, a former president of the Israeli Court of Appeal, is the concept, human dignity, that binds everything, all the human rights together, they say. Now that means that this concept of human dignity is this, that the protected dignity is the right not to hear anything different from an approved view. That's where this judgment is going. And the plurality said that silent but reproachful observance of a person entering into a clinic may be as effective as deterring someone from seeking treatment. Silent observance deters someone from taking a step which is part of the approved thinking of the community. And that undermines the whole concept of protest, because the whole concept of protest is to challenge lawful thinking. Cover that. Justice Gagler went our way on almost everything. He said the burden was discriminatory, it was direct, it was substantial, that the implied freedom doesn't protect offensive speech, but he went against us in the end. Justice Nettle said that the freedom is not a license to accost people, and Justice Gordon said that there is nothing protectable about seeking to shame strangers from changing private lawful views. And again, this concept is that you cannot challenge a private lawful view if it's part of the approved view. But that is the whole concept of protest. Things change because people protest things which are lawful to change them. Justice Edelman said there is almost beyond doubt that this law would be invalid in the United States. And I have to disagree with Joshua. The implied freedom is nowhere near as strong as the First Amendment. In fact, this case shows it. So, in conclusion, the battle for religious freedom is ongoing, but we are going to fight. We will never surrender. That's why we've established the Human Rights Lobby, and that's because the Proverbs tell us that those that seek, they that forsake the law praise the wicked, but such as keep the law will contend with them. We will never surrender. Thank you.